right, ma'am, you're Victavia Sanders.
Yes, ma'am.
And Ms. Sanders was previously here in cause number 22-39884. Entered pleas of true to counts 2 and 3 and a motion to revoke community supervision. I received an updated pre-sentence report. We're here for a sentencing hearing. Has everyone had an opportunity to review that report?
Judge.
Yes, Judge.
Are there any additions or corrections to the report?
Your Honor, my concern, I guess I can address this after Mr. Smith had the opportunity to present evidence on the new offense, was that the recommendation appeared to be predicated on an assumption that the new offense had been proved up, and that was going to be my issue with the pre-sentence report. Of course, if Mr. Smith is prepared to prove it up, then
Okay, let's go through that.
the necessity for me to go into that.
All right, we'll go through that first. And it's my understanding, and we spoke earlier, kind of off the record, that the officer involved is unavailable, but that Mr. Smith has his body cam video footage from that date, and there's no objection to him putting that on as evidence in this hearing. Is that correct, Mr. Kimler?
Yes, Your Honor, that's correct. My understanding is due to the exigencies of the officer being involved in the shooting, he's on administrative leave and is unavailable to testify. I therefore don't have any objection to the body cam being played in his absence.
Thank you, Mr. Kimler. And just let me know when you're ready, Mr. Smith. And Ms. Lopez is here. Thank you, Ms. Lopez. And at the appropriate time, if you have anything to add as well, I'll give you an opportunity to do that. And so the allegation in count 1 that was not pled true to or not is the allegation of a new theft of property from July 31st of 2025 here in Jefferson County. Or to count 1.
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you told her not to do this anymore. But I think that first video kind of sums everything up.
All right, any evidence with regard to count 1 before I make my finding?
Evidence, Your Honor, is in testimony.
And anything that could,
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
they didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and
She
so,
followed the direction. And there's
Yeah.
no Miranda issue since she wasn't
right.
arguably in custody. I don't have any argument. I will go ahead and object that that's an illegal search.
All right, that objection's overruled. I am going to find count 1 true. And so, let me see, I need to. Counts 2 and 3, she pled true to, so there's a finding of true. Count 2, again, everyone's had an opportunity to review that pre-sentence report. Mr. Kimler, you may make argument with regard to
Yes, Your
punishment.
Honor. At this stage now that the state has offered evidence as to be a new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would again defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose. I don't know if it's the next word.
With the pending charge of this theft, she's not eligible to go to ISF.
If I may, she's set on that today. I can resolve that today in this.
No, it's pending in felony court.
It's here,
Oh,
it's
is it here?
mine.
Okay.
Because of the prior
All right.
thefts.
All right,
She's done with misdemeanor
right.
thefts.
We could resolve that perhaps today, Your Honor, if the court.
I mean, I'm, go ahead.
The state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she'll be revoked and sent to the state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated
No, ma'am, I put
report?
everything in my recommendation.
All right.
Do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've ever been away from my kids besides when I did 8 months, but they was younger than me, and like, I was younger, and like, they understand what's going on. And I understand, and like me being away from my kids right now is really hard, cause they be with my mama, and my mama had dementia, and she.
Stop. Stop with everybody else. Because I'm not gonna make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me,
No, I'm
that
not.
if I send you to prison, that I'm somehow gonna be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was gonna happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again. And you did it again. It just makes me look like an idiot for giving you the opportunity in the first place. At some point, you have to stop. Some point you have to stop. Anything else?
Judge, even based on what she told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation. I
Right.
wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
Accept responsibility.
How is this my responsibility?
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm gonna tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, you're all, if you're in there doing it, you are the wrong person, right?
Yes, ma'am.
So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to,
I'll get the other one worked out today.
okay, I'll hold it while, all right, well, you're Robert Felix Jr., Joseph Jr., and will your client waive the formal reading of the motion in each case?
He will, Your Honor.
In cause number 21-38610, I have a motion to revoke your community supervision. Shows that you were placed on probation May 8th of 2023 for the first-degree felony offense of manufacturing or delivering a controlled substance. And that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes.
In cause number 21-38611, I also have a motion to revoke your community supervision. Shows that you were placed on probation May 8th of 2023 for the third-degree felony offense of unlawful possession of a firearm by a felon, and that was also a 10-year sentence that was probated for 10 years. Is that correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of public intoxication October 3rd of 2025, and is that true or not true?
True.
Count 2 in each case alleges that you failed to maintain your financial obligation to the GPS device company, failed to charge that as well, and is that true or not true?
True.
And then count 3 in each case alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 in each case freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true? In both of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand if I go along with this agreement today that you'll be waiving or giving up any right to appeal? Do you also understand if I go along with this agreement that this is a huge opportunity based on your history and what you're in here for?
Judge, may I provide the
Sure.
explanation
Yes, ma'am.
to the court? I certainly agree with what the court just said. I know this defendant from his being here before. He's not somebody that needs to be in this courtroom. He's 18 hours shy of college degree. He was a college football player. He got totally off track.
Yeah.
And has just, I've spoken with him in the back. I've spoken with his probation officer. She asked that the court consider this sanction and allow him to be released for the holidays with the understanding that the pretty low offer that Mr. Rojas and I had discussed previously is now off the table, that he will be on zero tolerance if the court would allow, that he will have to continue to have that GPS on and show you that he can do what he's supposed to do with it. He was hemming and hawing back there about how much he spent on it, and I told him, in my opinion, he's gonna have to prove to you that he can stay on that GPS and do what he's supposed to do and do what Ms. Bradley asked of him, what you asked of him. And if he does that, I'm willing to give him the opportunity, if you are, with the understanding that if he's back, I will ask for the full time.
So, and I recognize you as well, and I know you shouldn't be in here, and it looks like you were doing well for quite some time. And so I'm gonna do what everybody feels like you have the opportunity, your probation officer, the district attorney's office. Because of the nature of the offense and what was going on, at least for some amount of time, you're gonna have to wear the GPS monitoring device. And so I know it's not cheap. You're gonna have to get a job and figure it out. It's very important. It's charged at all times. It's paid for. I've gotta know where you are and that you're doing the right things.
Yes, ma'am.
If you do that for some amount of time correctly, it's always charged, it's paid for, you're up to date, then you can ask your probation officer to ask me if I'll let that go, and I probably will.
So I can ask you directly.
They send me, so I have a box in my office that I get a pile of stuff from probation every single day. Early terminations, requests for monitoring device to be, all of those things. But they're not gonna send it over and ask me on your behalf if you have not done everything you're supposed to.
They told me I had to hire another lawyer.
Well, they can send it over. Now, if you want to, a lawyer could file a motion, they can send the request over for you. But, and I'll take a look at it and see what all's been going on and talk with your probation officer again about how long you've been on it and what's been going on. If there's any change, I'll let her know. But for now, based on the new allegation, you need to get it, keep it, and then I'll reevaluate that, okay?
Yes, ma'am.
So this was a plea agreement, obviously, that I followed, and so you've waived any right to appeal. I handed you the trial court certification that shows that, all right? Good luck to you, sir. You can go back with the bailiff. Oh, and so, sorry, I feel like I skipped everything, actually. So the agreement was also for 60-day jail sanction, and that's with credit for time he's been sitting.
Yes, Judge.
And he has you've been in there.
Day 64.
Okay, so, state tenders number 1.
No objection.
It's admitted, any evidence that Mr. Joseph is not competent.
Okay.
All right, then I am going to, again, follow the agreement and continue you on probation, order that 60 days up front as a, but with credit for it as a sanction in both of your cases. And so you should be released today, it sounds like. Go straight to probation, get everything back in order, and then you'll be fine, okay? All right, good luck to you, sir. You need one too? We'll see you back at sentencing. You can go back with the bailiff. Good morning. Are you Tyree Hartley? And Mr. Hartley, in cause number 25 DCCR 0842, you're charged with the first-degree felony offense of aggravated robbery, and that's from April 22nd of 2025. Your indictment alleges that you were previously convicted of harassment by a person in a correctional facility, a third-degree felony, August 5th of 2013. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, a third-degree felony, December 21st of 2022. And then again, an evading arrest or detention with a vehicle, November 13th of 2023. And what that means is that if you go to trial and you're found guilty, you would be considered a habitual offender, and your minimum punishment would be 25 years in prison up to 99 years or life. Do you understand? Answer out loud, please, for me. Thank you. And I have here on the tablet a plea bargain rejection that has your signature with Mr. Parker's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to waive that enhancement for habitual for a 20-year sentence in prison. You have every right to reject that. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject that offer and go to trial? And is there any reason to believe that that offer would change?
No, Judge, it would go up substantially.
So I want to make sure you understand, I don't want to accept that offer after today either, okay? And so if you change your mind, you can plea open to the court or to something else, but it won't be to that, all right? So I will put your case on the trial docket. Mr. Parker's been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Parker, you're released. We will. Good morning. Are you Adrian Banks? And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Banks, in cause number 25 DCCR 1432, you're charged with a third-degree felony offense of harassment of a public servant in count 1 of that indictment, and that is from September 1st of 2025. And how do you plead to that charge?
Guilty now.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am, I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Banks is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of, in count 1, of harassment of a public servant, sentence you in accordance with your agreement. It was 2, right? To a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with me.